Good morning, everyone, and welcome to our webinar this morning on planning for the future, personal directives, and powers of attorney. I know some of you are still coming in, so we'll do a bit of an intro before we jump into the substance of our discussion this morning. So by way of introduction, my name is Jessica Steingard, and I am a staff lawyer at the Centre for Public Legal Education Alberta, or CPLEA for short. And our mission is quite simple, and that is to make the law understandable for Albertans. So we are a nonprofit serving all of Alberta, and we provide free legal information and education through our various websites, info sheets, booklets, webinars, videos, you name it. We like to get it out to everyone. Before we move on, I would like to acknowledge that the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. I am in Edmonton in Treaty 6, but we know people are joining us from across the province and even beyond. So welcome, everyone. You do see a couple of faces at the top of your screen as well. We have some of our panelists this morning. I will introduce them in just a few minutes when we get to our discussion. Just a quick disclaimer this morning. So this presentation contains legal information. It is not intended to be legal advice. We also wish to acknowledge the generous funding provided by the Alberta Law Foundation and the Department of Justice Canada that make presentations like this one possible. A few more housekeeping items. We are recording today's presentation. That is so that we can make it available to you afterwards to watch on demand on our YouTube channel. So we'll be sending out an email with the link to that once it's posted. And also, we're going to try and save lots of time at the end for questions. We ask that you put your questions in the Q&A function. You can drop them in whenever throughout the presentation, but we will wait till the end to answer them. So just make sure you're dropping them in there, and then we will get to them. Okay, well, let's get started today then. So where are we going today? What do we want to cover? We're going to start with the basics. So we're going to give a quick overview of personal directives and enduring powers of attorney. Following that, we're going to have a panel discussion, which is why the faces on your screen, Amy and Lincoln, are here today. So we'll have lots of time to get through some common questions that we hear around personal directives and enduring powers of attorney. Before we get started, though, we're going to pop a quick poll up on your screen. I think there's two different questions, just to kind of get a sense of where everyone's coming from this morning and what their knowledge is of these topics. Okay, and we'll get those results up. Okay, so it looks like we're in the somewhat familiar range for topics, but we've also got some room to learn, hopefully. And we will be talking more about our resources at the end. So hopefully we can bump that question up there, and you will all be familiar with CPLEA's resources on personal directives and powers of attorney. Okay, let's dive right in now. So the first thing we're going to look at is, what is mental capacity? So as you know, this is actually part 3 of a 4-part series on planning for the future. So in part 1, we covered mental capacity or decision-making capacity. And in part 2, we covered making a will. So I'm going to pull from that first session a little bit and do a quick review before we move on. So we talked in that first session about mental capacity, or also called decision-making capacity. And that is the ability to understand information that relates to making a decision, and the ability to appreciate the reasonably foreseeable consequences of making or not making that decision. So that's our definition of mental capacity, which comes from the Adult Guardianship and Trusteeship Act. The other piece of review is the different types of decisions. So when we're talking about decision making, we group decisions into 2 categories, and that's personal and financial. So when we're talking about personal decisions, we're talking about decisions about healthcare, living arrangements, associates, so who you spend time with, your social activities, your education, work, and any legal proceedings that are not about finances. Financial decisions relate to buying, selling, managing, or protecting property. So for example, it has to deal with everything from your home, your money, so it might be cash or in bank accounts, investments, and all of your belongings. The concept of mental capacity and these two types of decisions are important in our discussion today. So that's why I wanted to just do a quick refresher on those two topics. Okay, so one of the documents we're going to be talking about today is a personal directive. So what is a personal directive? Well, it is a written, signed, dated, and witnessed legal document. And I've highlighted those four terms because those are the four things that make it a valid legal document. It must be in writing, it must be signed, it must be dated, and it must be witnessed or signed by a witness. It is important that the person who makes the personal directive and the person who witnesses the make or sign it, that they do that together. So they must be in the presence of each other. And then what does it do? Well, it gives someone else the right to make personal decisions for you when you no longer have capacity to do so. So now we're seeing that tie into the mental capacity component, and we're seeing the tie into that personal decisions or the types of decisions that we were talking about earlier. Personal directives in Alberta are governed by the Personal Directives Act. This is an Alberta piece of legislation, and so different provinces might have different rules when it comes to personal directives. An enduring power of attorney, the other document we're talking about this morning, is a written, signed, dated, and witnessed legal document. So again, we have those four legal requirements that it's in writing, it's signed, dated, and witnessed. And again, the person making it and the witness must sign in the presence of each other. And then what does it do? Well, it gives someone else the right to make financial decisions for you when you no longer have capacity to do so. And again, this is governed by a piece of legislation in Alberta called the Powers of Attorney Act. Now, we've talked, that definition pertained to an enduring power of attorney. You may have heard of just powers of attorney in general. Sometimes we call them general powers of attorney or just plain old powers of attorney. They are something slightly different. So a general power of attorney, as defined in the Powers of Attorney Act, is only valid when you have mental capacity. And it can be for a specific or broad purpose. So you might see an issue here. If I have a general power of attorney I've given someone for some purpose, and I lose mental capacity, now it's no longer valid. And so that's why we have the enduring power of attorney piece that says that it must say that it continues in effect after the donor loses capacity, or that it takes effect when the donor loses capacity. So you might be wondering why we have, just a general power of attorney and an enduring power of attorney. General powers of attorney can be useful in certain situations. So sometimes they're used, say you're going on vacation for 6 months and you need to pay your rent during that time, or you need to pay bills, or you're receiving benefits or income or whatnot, and you need someone to manage that for you while you're gone. You could give them a power of attorney to help you with those financial decisions while you're gone. So that could be a very specific purpose for a specific period of time. And again, throughout that whole time, you have mental capacity. When we're talking about an enduring power of attorney, we're talking about, usually when you lose mental capacity, either as you age or due to an illness or, an accident of some type. That's when we're talking about the use of an enduring power of attorney. So hopefully that clarifies different uses of powers of attorney. So just a quick recap then and kind of separating out some of the differences between a personal directive now again and an enduring power of attorney. So under a personal directive, you are called the maker. The person who makes it is called the maker, and they give a person called their agent the authority to make personal decisions for them. Under an enduring power of attorney, the person who makes it is called a donor, and you give a person called an attorney the authority to make financial decisions for you. So hopefully that lays out just the different terms that we use and the differences between them. And so we start to see that very clearly: personal directives, that personal decision piece, enduring power of attorney, financial decisions piece. but both of them are used when we no longer have capacity to make decisions. So who can make these documents? Well, you must be 18 years or older, and you must have mental capacity when you make the documents. We talked 2 weeks ago when we were talking about making a will, we talked about the mental capacity that's needed to make a will. We talked about it being testamentary capacity, and there was a description of what that was. When we're talking about making an enduring power of attorney and a personal directive, the standard of capacity, I guess, or the level of capacity you need is the ability to understand the nature and effect of the documents. So that's what we're looking for when making a personal directive or enduring power of attorney. And the other question that is common is, when do these documents take effect? So do they come into effect as soon as I make them, or do they come into effect at some later time? Well, it depends on the document. So when we're looking at personal directives, the legislation clearly says that they only come into effect when someone loses capacity with respect to that matter. So they can no longer make a personal decision about something. The way it comes into effect depends, though, on what the document itself says. So you can name someone in your personal directive who can make a declaration saying this person no longer has capacity. They don't necessarily they don't have to be a doctor. It could be, even your agent. But if you do name someone, such as your agent, they're going to fill out a form called a declaration of incapacity. They're going to fill out the top part. But a physician must fill out the declaration as well. So you can't just have someone saying, with no medical knowledge saying, yep, this person's incapacitated. The declaration does need to be completed as well by a physician. If you don't name someone specifically in your personal directive, most personal directives do say that it's two service providers that must declare that the person no longer has capacity, and a physician or a psychologist must be one of them. So that's the two service providers is kind of the default position. When we talk about an enduring power of attorney, it's a little bit different. So they can take effect when they're signed, if that's what the document says, or they can take effect on a certain date or a certain event. We really have to look at the document itself to see what it says. Most commonly, enduring powers of attorney are written to say that they take effect when the person loses capacity. And so that's the certain or specific events that we're looking for. And again, who gets to determine whether the donor has lost capacity? Again, you can name someone in the enduring power of attorney to confirm, or the default position would be two medical practitioners that can make that declaration for you. Okay. That is the very fast 12-minute basics version of enduring powers of attorney and personal directives. We've just kind of skimmed the surface on these two topics. What we really want to do is have a panel discussion, though, and draw out much more information about these. So this was kind of meant to give a very brief overview of the documents and understand what they are and the differences between them. But now we're going to move into our panel discussion, which is where Lincoln and Amy come in. So I'm going to start with Amy Abbott. She is a partner at Emery Jameson LLP in Edmonton. She practices primarily in the area of wills and estates and advises clients on a range of estate planning and estate administration matters. A portion of her practice is dedicated to disability law, and she regularly advises clients on guardianship, as well as planning for dependent adult children. So thank you, Amy, for joining us. We also have Lincoln Marr. So Lincoln obtained his undergraduate degree and law degree from the University of Alberta. I started working for the public trustee in 1990 and was seconded to the public guardian's office in December 2010 to assist with the implementation of the Adult Guardianship and Trusteeship Act, which we previously mentioned. So that legislation came in then. Lincoln became a permanent member of the Public Guardian's Office in December 2011 as a review officer and trusteeship specialist, and is currently a review officer and trusteeship specialist with the integrated office of the Public Guardian and Trustee. So fun fact, it used to just be the Office of the Public Guardian and the Office of the Public Trustee. but now they're combined. And now we have the Office of the Public Guardian and Trustee. So Lincoln is joining us this morning as well. Oh, I should put your name up. There we go. So thank you, Lincoln, for joining us as well. So Lincoln and Amy, combining your last name. Okay, Lincoln and Amy, let's get started on our questions. So our first question is, what is the role of a lawyer or the Office of the Public Guardian when it comes to these documents? And Lincoln, I'm going to start with you.
For sure. Yeah. So starting with the OPGT. So our office has, even when we were separate, two offices, we have always encouraged individuals to consider making these advanced planning documents, personal directives, powers of attorney, enduring powers of attorney, and wills. We've done seminars and talks like this and so on. The thing that we can't do is we can't help people draft the documents themselves. The legislation does allow for the documents to be done without the assistance of a lawyer, but our advice has always been, if you're at all uncomfortable, when go and read the legislation and the regulation, particularly with the personal directives, there's actually specific forms that you can complete and so on and so forth. If you're at all uncomfortable with completing it yourselves, we always recommend that you go and see a lawyer. Most lawyers will talk to you without charging you about your situation, what you need, how much it'll cost, all those kinds of things. And so, we usually encourage people to look at the legislation, look at our website for more information and so on. But if they're at all uncertain about what they should do or what it should say or whatever, we always suggest that they see a lawyer.
That's where Amy comes in.
Yeah, I'll jump in there. As someone who advises on estate planning, I can say that a lawyer will identify the preparation of an enduring power of attorney and personal directive as important pieces of your estate plan in addition to your will. So a lawyer can help you to understand what the difference between those documents and a will is, and what kind of information and considerations need to be taken into account to prepare a power of attorney and personal directive that accounts for your circumstances, but also dovetails, so to speak, with your will to the extent that may need to be taken into account. And a lawyer can also help to explain the difference between different kinds of powers of attorney, which Jess had covered. We sometimes call them an immediate enduring power of attorney versus a springing enduring power of attorney. And which one you need can depend very much on your circumstances. So for example, for elderly clients who are fully capable of managing their property and finances, but maybe want a little help from one of their adult children to do that, a lawyer can help you to understand the use of an immediate enduring power of attorney to achieve that versus springing enduring power of attorney, which doesn't come into effect or give any authority until you actually lose capacity. And I think the other important piece that a lawyer helps with these documents is ensuring that they're executed properly, that they're drafted to meet all the requirements of a valid personal directive and enduring power of attorney under the legislation. An important piece of that is ensuring that they're properly witnessed, because the legislation does specify that certain people cannot witness those documents, including an agent or attorney named in the documents or the spouse of an agent or attorney named. So a lawyer can make sure that all the appropriate requirements for a valid power of attorney and personal directive are covered.
Perfect. Thank you both for that. Okay, so now that we understand some of the different roles, let's move on to question 2. Why is it so important for people to make a personal directive and enduring power of attorney? And what happens if they do not? And I'll start with Amy on this one.
Sure. So the importance of these two documents is really to make sure that there's a contingency plan in place if you lose capacity. And that's to ensure that in that event, there is someone who you've chosen, who you trust, to make those decisions on your behalf. And incapacity is one of those things that, unlike death, is not certain, but because life is unpredictable and we don't know what may happen, it is very important to have those documents in place. If you don't have them in place, and I know Lincoln will be able to speak to this in greater detail than me, but I'll just touch on it and maybe turn it over to him. If you don't have these documents in place and you lose capacity over personal decisions, a guardian would need to be appointed by the court under the Adult Guardianship and Trusteeship Act to make those decisions on your behalf. Likewise, if you lose capacity to make decisions about finances and property, then a trustee would need to be appointed by the court under that same legislation. That process involves quite a bit of paperwork, I have to say. It's a much more involved process in terms of time, effort, and expense if you're having a lawyer assist you to do that, as opposed to having a lawyer or just having a power of attorney and personal directive prepared in the first instance.
For sure, Amy, all of those things are exactly correct. I just, yeah, so again, it's important to it's kind of the advanced planning, particularly with mental incapacity. I agree. A lot of people kind of want to say, well, that'll never happen to me, you know, but accidents happen, all sorts of things happen. 2 years ago, would we have thought coronavirus, COVID would happen? No. And here we are 2 years later. So you just never know. So sometimes I think it gives people, it should give people a little bit of peace of mind, particularly because it allows them to choose who will be making these decisions for them when they're not able to do so themselves. I think really that's the, you know, setting aside the costs and all that, that's really the most important thing, that you've thought about it and you've decided, because you're right. So if you don't have a personal directive and you become incapacitated, I mean, there is the specific decision-making ability in the legislation, which allows someone from a chosen list of the doctor's contact and so on and so forth to make medical decisions and residential facility placement decisions. But other than that kind of very narrow scope, if you lose capacity and you don't have anyone else to make personal decisions, then guardianship is going to have to be obtained through the courts. And you obviously, since you're incapacitated, you have no, well, I don't want to say you don't have any ability, but normally you can't say who you want to make that application, who's going to be your guardian or guardians and so on. And again, depending on how incapacitated you are, you may not be able to provide any input at all as to if you want your oldest son, your youngest daughter, whoever it is that you would have normally chosen, had you thought about it, to be able to make those decisions on your behalf. With respect to financial matters, there is no in between. So if you don't have an enduring power of attorney, you lose capacity to make financial decisions, then trusteeship has to be applied for through the courts. And again, like I said, you really don't have the ability to decide who's going to be that applicant, who may end up having authority over all of your financial affairs.
Awesome. Thank you both for that. Both Amy and Lincoln have touched a lot on, you know, that choice that you can make and, you know, that preparing beforehand, thinking about it beforehand, making a decision and choosing who you want to make decisions for you. And that is sort of comfort for yourself. But I think the other thing I wanted to just quickly mention or touch on was that in doing so, you're also providing a lot of clarity and peace for your family and close friends that, you know, if you all of a sudden lose capacity, there is some sort of peace because there's clarity around who actually can take that position. And so, you know, it's not just for you, but it's also for your, you can offer that for your family as well. Okay. We're going to move on to question 3. What should people think about before choosing an agent or an attorney? And I'm going to start with you on this one, Lincoln.
Well, as I mentioned, you know, to me, it is really the most important decision. It's someone that you trust to make the decisions in the way that you would have made them had you had capacity to make them, right? So it's not, it's not necessarily someone who you think has made these great decisions about their own life, but it's someone who you can speak with, who knows you enough, or who you can convey, your wishes, beliefs, and values, so that when it comes to your decision making, they would know what you want, even if that's not what they would choose for themselves. Right? I think that's the biggest thing. And I also want to, kind of go back to what you said. In all of our education from the OPGT, we always want to tell people, these enduring powers of attorney and personal directives, and to a certain extent, even your will, they shouldn't really be these private documents that only you and the agent or you and the attorney know about. Because exactly what you said, if we've had situations where someone has a personal directive, they've only discussed it with the agent. One of their 4 children they've named so and so to be their agent, and then when they do lose capacity, all the other kids are going, oh, what should we do? Do you need to apply for guardianship? And someone pulls out this personal directive. Oh yeah, well, 2 years ago, mom signed this thing, made me, and I get to make all the decisions. That is the situation that making this document is supposed to avoid. When you make it, you're supposed to convey to all the other people that you've thought about it, you haven't been influenced, you chose this person, and whether anyone else agrees or not, that's their own problem. But you're telling them, while they know you have capacity, that you've chosen this person to make those decisions. And then hopefully, if it does come time for that person to start acting as agent, that the other people will realize that, this is a decision that was made by the maker, not, sprung on them or something of that nature, right? So that's another important piece of, again, trust who you choose as agent, but also convey that information out to the other family members and so on, so that it isn't a big surprise.
I agree with everything that Lincoln just said, especially the trust component. That's really the first thing. Sometimes clients will ask me, well, who should I appoint? And that's the first thing I will say is it needs to be somebody that you really trust, first and foremost. Secondary to that, I think you need to be confident that the person you're choosing or people that you're choosing are capable and up to the task required under each document. For a personal directive, because it covers your healthcare decisions, those can be very emotional decisions for an agent to have to make on someone's behalf, a parent, especially if it's a parent or another family member. So an important consideration is, confidence that the person will be able to do that, to carry through and to exercise your wishes as you've expressed them, or to act in your best interest if your wishes weren't clear. Likewise, with a power of attorney, important to choose somebody who you feel confident will understand your finances, will be able to manage your banking, your investments, whatever may need to be done each year in terms of your income tax filings, as well as managing any real property that you own in terms of whether you continue to live there, making mortgage payments, or perhaps renting that property out or even selling it. So trust and confidence in the abilities of the person, depending on the role, are really important. And I think other considerations are the age of the people that you're choosing. You can certainly select someone who is older than you, but you do want to be mindful if you do that you may want to have an alternate appointed. And we always recommend that you have a secondary. Sometimes people will even appoint a third alternate, just in case your primary choice isn't able to fulfill that role. And something else to consider is the location of where these people are, especially, well, I shouldn't say especially, I was going to say especially for the power of attorney, because of the nature of the decisions can involve things like your banking and whatnot. Having someone who lives fairly close to you is usually best. But for the personal directive as well, it's not necessary that the person reside in Alberta, but it can can certainly make things easier logistically if they do live nearby. So it is something to consider, whether they're located close to you, and if they're not, how easy it would be for them to do what they need to do remotely or travel back and forth. And I don't want to go on too long. The only other thing I wanted to mention was you can appoint people jointly as well. And if you're going to do that, another important consideration is whether those people can work together cooperatively and get along, and that you can trust them to work together.
Perfect. Thank you both for those lots of information there and different perspectives on it. The one piece I wanted to clarify, and I don't think you answered this in the first one, for Lincoln is, can people name the Office of the Public Guardian and Trustee?
The Office of the Public Guardian can be named as an agent, but just like any other individual, if you name us and you don't tell us you name us, then we can always refuse, right? So our policy, right, would be if you really don't have anyone else that you want to name as agent, then you would contact our office and say, I don't have anyone. Then we would have a discussion with you about what your needs and so on, and determine if it would be appropriate for our office to act as agent. And if so, on and on, we go with the process. Just because depending on what the individual wants in terms of, if they become incapacitated or maybe life-saving things or whatever. There are some things that the public guardian couldn't consent to or do or whatever, if that was the individual's wish. So again, that's why we have this discussion, this meeting, to see if it would be appropriate for our office. Yeah, so the Office of the Public Guardian can be an agent. The Office of the Public Guardian and Trustee will not, as far as I know, it was the policy, will not agree to act as attorney for an individual under an enduring power of attorney.
Perfect. Thank you. Okay. I see there's lots of questions coming in, so I'm going to keep moving along on our discussion so we can get to those afterwards. Okay. So fourth question, what common misconceptions do people have about making powers of attorney and personal directives and enduring powers of attorney? We've talked a little bit about some of them, but if you just want to draw some of them out a little bit more, and we'll start with Amy.
I think one of the most common misconceptions is that a personal directive or an enduring power of attorney is part of your will or is the same as a will or is part of that document. So it's important to understand that they are three separate documents. A will, a personal directive, and an enduring power of attorney are three separate things, but they are all part of an estate plan and an advanced care plan. Sometimes people will also confuse, especially a personal directive, with something like a green sleeve or goals of care. And it's important as well to understand that those are different things. The goals of care or a green sleeve can certainly inform an agent's decisions under a personal directive, but the personal directive is really what grants that person authority to make those decisions. The other common misconception I think people have, which we've touched on already, is, especially if you're young and in good health, that you don't really need those documents in place. And I would say they are just as important if you're young as they are if you are older, because life is unpredictable, as we know, and it is better to have those documents in place than not in the event of an accident or anything like that.
Lincoln?
Well, you took two out of the three that I had listed here. So one misconception that we hear quite a bit is that when they hear about the cost of doing a personal directive and enduring power of attorney with the lawyer, right, they say, well, that's a lot of money for something that I might never have to use, and so on and so forth. And we always try to advise people, well, it's kind of like buying insurance. Often you don't want to use your insurance, but you pay for it because just in case. And, we also do try to advise them that, ask the lawyer how much it costs to do a guardianship and trusteeship application. And then you'll see that $300 or $400 or whatever you're paying is quite a bit less. It's factors less, multiples less than doing even a very simple, straightforward guardianship and trusteeship application. You know, so that people often see that the cost it seems too much. It isn't compared to the cost of the alternative. Another misconception that we've heard, less so now, but still we heard, is that people think that, well, if you don't have these documents, well, if I become incompetent, whatever, my spouse can make those decisions, or my children, or someone else in my family. Like usually it's your spouse. You go, well, can't my wife, if I'm in the hospital, if I had a car accident or something, can't my wife make all these medical decisions or whatever? And of course, that's not true, right? Again, subject to the specific decision-making process that exists. Generally speaking, your spouse doesn't have any additional authority over your personal decision-making, and certainly not over your financial decision-making, than any other ordinary stranger type of thing. So I think those are some misconceptions that people have.
Excellent. You've certainly covered ones that we hear as well through our info and referral line, especially, and it gets me every time that, you know, I'm young and healthy and I don't need it. And you kind of just go, well, I could be hit by that proverbial bus tomorrow. So it's, you know, better to be prepared. I kind of think it's something that, you know, when you turn 18, everyone should get a will, a personal directive, and an enduring power of attorney. They're kind of really necessary documents. Okay, let's move on. So past the conceptions. This question has to do with concerns. So what if people have concerns that their or someone else's personal directive or enduring power of attorney are not being followed? Lincoln?
Well, with personal directives, the Office of the Public Guardian, if you can actually make a written complaint to the Office of the Public Guardian that someone isn't following the personal directive or is making bad decisions and so on, and we have an investigative process that will be followed to determine if yes, the person is doing what they're supposed to be doing, or no, they're not. And then obviously, if they're doing what they're supposed to be doing and someone just disagreed, that's, you know, kind of one category, and you know, that's where the education part of our office comes in, where we try to educate all the parties about, well, yes, this is their responsibility. We know you might not disagree, but you know, we've determined it's still being made in the best interests of the adult. So, you know, we proceed. If it's determined that they're not making the correct decisions, you know, usually our office will kind of, again, looking at the education first before kind of, you know, punishment or anything like that. We'll deal with the agent to try to see if there's a particular reason or something they didn't understand or something of that nature. And then, you know, kind of at the end of the line, it's possible that either our office, if there's no one else, or we might try to determine if there's someone who might apply to be guardian for that individual if the agent is still kind of not willing to act in the appropriate manner, type of thing.
Perfect. Oh, and Amy?
Yeah, and in addition to the process that Lincoln just covered, under the Personal Directives Act, an application can be brought to the court if there are concerns. So just to know that there is some provision under the legislation. If you had a concern about a personal directive not being followed, an application can be made to the court for some kind of direction, and there are a number of remedies that the court can provide. I won't go through all of them, but depending on what the nature of the concern is and whether it's substantiated when it's reviewed by the court could potentially revoke the personal directive. They could override a decision that an agent has made, and then they have actually quite broad authority to make really any other order that they deem appropriate in the circumstances, so long as it isn't inconsistent with the personal directive. There is that parameter on it. Similarly, with an enduring power of attorney, if there is a concern that a power of attorney isn't being followed, the Powers of Attorney Act has a similar mechanism that allows an application to be made to the court. The difference is that application is an application to have the attorney provide an accounting of how they have managed the person's finances. And so usually the first step before you would go that far would be to request that accounting, that the attorney provide that voluntarily before you try to compel them to do that through the court. But if they won't do that, there is this section in the Powers of Attorney Act that allows an application to be made. Now, depending on the accounting that's provided, for example, if it showed that there had been mismanagement of the finances, potential financial abuse, the Powers of Attorney Act does give authority to the court to actually revoke that attorney's appointment. The catch is the court can't appoint a new attorney. All they can do is direct that the person who applied for the accounting or someone else bring a trusteeship application, and they can appoint an interim trustee until that application has gone through.
Perfect. So lots of information there about different complaint and court processes. I do want to clarify as well, we've talked a lot about attorneys and, the what we would look for in an attorney and an agent, and we've talked a little bit about in this question too, that there's actually legislative rules for those people. So there are, they have duties. We usually say fiduciary duty, but they have responsibilities as well. And so if they're not performing those responsibilities, then they, we've just talked about some of the ways that they can be held accountable for those. So on the flip side, if you are someone who is being asked to be an attorney or an agent, I think it's also important to understand not just, that person's decisions and what you're going to have to do for them, but also the legal responsibilities of that role. We didn't really talk about it. Amy kind of mentioned it, the accounting, their responsibilities to keep records and whatnot as well. And so important for the attorney and the agent to also know what they are doing as well, which is why it's so important to have that conversation. You don't want to name someone and then all of a sudden, it's the 19th hour and this person's going, yeah, no, I don't want that responsibility. So really important to have that conversation first. Okay, well, we have one more question, which is good. We're leaving lots of time for the Q&A, which I see there's some great questions in there already. So we're going to move on to our last question today for our panel discussion, which is what other resources are available for people wanting to learn more about personal directives and enduring powers of attorney? And I'll start with you, Amy.
I think things like this are a great place to start. Resources provided by CPLEA are really great. There's other legal clinics in Alberta that will provide similar resources, sometimes webinars as well. I believe the Edmonton Community Legal Centre is one. There's actually great information on the government websites, which for those of you who attended the Will session, I think I mentioned that as well. But it similarly provides a nice overview of personal directives and powers of attorney and touches on the legislation that governs each of those in a way that's nicely digestible, I think. And then, of course, I would encourage, I can't speak for other lawyers, but I think most lawyers are quite open to inquiries about powers of attorney and personal directives. So, to reach out to get legal advice. Some lawyers will provide that consultation initially, even free of charge. So you can certainly try to access that legal advice as well when you're trying to decide how to proceed.
Yeah, Amy, I want to emphasize our website does have, we've done, not me personally, but the government and a lot of people in our office have done a lot of work to try to get useful, readable, non-legalese information on our website about personal directives and enduring powers of attorney and other kind of substitute decision-making options. So you can kind of go on there and you can kind of see the litany of from what you can do while you're competent to what happens if you become incompetent and what the process is and so on. Also wanted to mention that a little while back, but it's still relevant because the legislation has to change. Our office and the Justice Department, we did a series of YouTube videos. They were webinars at the time. They're now YouTube videos about personal directives and enduring powers of attorney. So if you go to YouTube and you search the Office of the Public Guardian and Trustee Alberta, They will come up and you can watch any part of the hour. And the best part is you can kind of fast forward through the boring bits, which some people might say might be all of it. But anyways, there is definitely YouTube videos on there. And as Jess said, these videos will also be on YouTube at some point, right? So, I mean, there's a lot of places where you can get an overview of what these are. But like Amy said, I think if you're, I don't want to say if you're really serious, but I think lawyers are probably the best place if you have questions, right? You can always contact our office, but we can't give you legal advice. We can kind of give you a little guidance, tell you what the legislation says and so on. But if you want information and advice about your specific situation, we think a lawyer would be the best person to ask.
Perfect. Thank you both. I think we've Natalie, who's one of the faces behind the black boxes on our screens, she's thrown up some links in the chat to some of the resources that were just mentioned. So a link to the legal clinics, to the Office of the Public Guardian website, which is, there's lots of information on there, and as well as the YouTube videos that Lincoln was just mentioning. Those are, the links are in the chat there. I do want to highlight, since I mentioned at the beginning, that we also produce public legal education and information resources. So we have several booklets on this topic. So I've highlighted a couple of the relevant ones here, making a personal directive and making an enduring power of attorney. So it goes through the legal requirements. So we talked about some of those today. Amy also mentioned, there's some people that can't witness. They can't witness your documents. And so who are those people? So these booklets are really great. They're available on our website. If you go to cplea.ca, and then when you, on the left-hand side, there's legal info, and you can select planning for the future, you'll see them all there. There's also a booklet. I talked a little bit about the responsibilities of attorneys and agents. We have a booklet specifically called Being an Agent, and one specifically called Being an Attorney. So again, talks about your role if you're being named as an agent or an attorney. So again, all available for free on our website there. I'll quickly mention oaknet.ca. It's a website that we have that's about Canadian law for older adults. And so you'll see there's a section on planning. And so we do cover these documents as well. But as we've talked about, these documents are not just for older adults. And so do want to make that clear as well. Okay, before we get to the questions, I want to highlight a couple upcoming webinars. So I did talk about this being the third of a series of 4. So our final series will be on the Adult Guardianship and Trusteeship Act, which we've talked a little bit about today. Both Lincoln and Amy will be back joining us for a discussion on that piece of legislation. That one's on March 2nd at 10 a.m. You can register for the same way you registered for this one. And before that, we have one on legal advice and legal info next week. So if you work somewhere where you have to know that distinction of what you can and cannot say, that's a really great webinar, a good refresher on that topic. And then on March 16th, we are doing a webinar on renting 101. So if you work in landlord tenancy or any type of area like that, that will be a great discussion about landlord and tenant laws in Alberta. Okay, we're going to move to the questions because I see some of them open and some of them are quite long, detailed questions. So I want to make sure we have time to answer them. Natalie is going to post the link to our evaluation survey in the chat. So please take 30 seconds just to fill that out. Let us know what you thought of today's presentation. It really helps us make sure that we can make them better if need be. So she's going to post that link in there. And in the meantime, I'm going to flip over to the Q&A. So I'll read the questions out, and then Lincoln or Amy, whichever of you wants to take the answer, just let me know. So there's a standard form for personal directives available through the government. I've been asked about the same for an enduring power of attorney. Usually I state they need to talk to a lawyer. Are the general ones found online okay? Or what problems could arise by using a general one?
I can field that one, and Lincoln, if you have any thoughts, feel free to jump in. It's true, there's, as far as I'm aware at least, there's not the same template form available for powers of attorney as there is for personal directives through, I think it's the government website. So it's good to be aware that caution should be exercised in using template powers of attorney that are found online. The things to be concerned about with using one of those, they may be fine, in that if they contain what is needed to meet the requirements of a valid power of attorney under the legislation, then as long as it's properly executed, it could be valid. The thing to watch out for, though, is it's something that varies by jurisdiction. So each province and territory has different laws on powers of attorney. So you need to be mindful of, this could be a template from a different province potentially that might have different requirements than Alberta. So I would say I wouldn't recommend using the template forms. It would be better to have it done through a lawyer, and not saying that as a plug for lawyers, but just out of an abundance of caution. Because, you know, to make sure that just the validity requirements are met is the main thing.
Lincoln, do you have anything you want to add?
No, she hit all the points. That one, there is no template provided by the government for an enduring power of attorney. And two, because often they're kind of generic to cover many jurisdictions, and powers of attorney legislation is specific to each province, that using a template may not contain the correct wording, may not have the right look or whatever. So yeah, we always say use at your own risk, which could be substantial.
And that's true, especially because people's financial positions can be very complex. And so if you want to make sure that everything's kind of covered in your power of attorney, you're not leaving out some important piece.
And I'll just touch on this briefly, because that reminded me, Jess, the other thing with using a template for authority to deal with real property, there's specific language that needs to be included in a power of attorney to give the attorney authority to sell land, for example. And so if you use a template form that doesn't have the right language, that the land titles office would need to see, that would be that's an example of a potential problem that you could run up against.
Perfect.
I was just thinking of that. It's one of those little tidbits that, unless you've either dealt with it or you're a lawyer who's dealt with it, it's not in the legislation. Unless you happen to read the land titles manual for leisure, you would never know.
Perfect. And now we've raised it for everyone. We've made even more awareness of it. So that's good. Thank you both for highlighting that. Okay. We're going to move on to our next question. We are seeing an increase in situations where the named attorney either A, isn't aware they were named, or B, is not interested in taking on this role. If an enduring power of attorney is enacted, can the attorney simply provide a written statement that they want to walk away? I've heard that if the attorney has acted and completed activities as the attorney, that they can't simply sign off. Amy?
Sure. I can, I'll try to answer that. So, so this is a good example of why it's best for the person to talk to the person they want to appoint, which I think Lincoln mentioned, so that you know that you're appointing someone who's willing and able to do it. To the question about can they provide a written statement? So my view would be, if they have not acted as the attorney, they should be able to renounce. There is a section in the Powers of Attorney Act, I believe, which says if the attorney has acted, that the court's approval of their removal is required. And so that, I think, is going to maybe what you've heard, that they can't simply sign something and walk away if they've already acted. Something more than that is needed. And my understanding of the legislation, I've never had to do it, but I believe the provision says that the court's approval is required for that to happen.
Perfect. Thank you, Amy, on that one. I'm going to move on to the next question. So what protective factors are there in the legislation to protect against financial abuse? We have a number of situations where the enduring power of attorney is actively, so I'm guessing where the attorney is actively mismanaging, not responsive, or making decisions that are required. The police and elder abuse teams are limited in their ability to block or remove the attorney. I understand a private or public trustee application can be submitted, but that takes time. What can we do in the interim to protect the donor. So we've talked a little bit, I don't know if this question came in when we were talking about that. We've talked a little bit about the concerns, what people can do about their concerns. Is there anything, Lincoln or Amy, that you wanted to add to that specifically?
There is one thing I should add, which I hadn't mentioned, which I think touches on this. When I was talking about the application that can be made to the court to require the attorney to provide an accounting, any interested person can bring that application. And it's interesting, the Powers of Attorney Act doesn't actually define who an interested person is. My reading of that is that it's broad, likely for a reason, so that an interested person could potentially capture, I think certainly a concerned family member, likely a concerned service provider, perhaps could even be so broad as to include somebody who's become aware of the situation and has a concern, could potentially bring that application. So that unfortunately is really the only mechanism in terms of protection under the Powers of Attorney Act, is to require the attorney to pass their accounts before the court. And if the court believed there had been abuse, then there is the remedy they can give of removing the attorney.
Perfect. Lincoln, anything you want to add? Are good.
Yeah, the only thing is, from obviously I've heard this question a lot about what to do about an attorney who's not acting properly. From a very practical point of view, and I mean, people try everything, and there's the old abuse team and so on. Particularly if you're dealing with a financial institution, one of the things we've often suggested, again, it's a practical, not a legal remedy, is to bring those concerns to the attention of the bank. Because the banks really hate risk. So if you bring to their attention that these things are going on that on the face of them seem very suspicious, right? Then banks have a lot of authority if they have suspicions to freeze accounts, to do all sorts of bank mechanism, bank law stuff that ordinary Joe can't just go and ask someone to do or whatever. A lot of it because if in fact they've been made aware of something going on and they just continue to let an attorney do something, and it's proven later on that the attorney was doing something wrong and they were made aware of it and they let it continue. Banks have very deep pockets. So sometimes, maybe a court-appointed trustee, when they're suing the previous attorney, well, maybe you'll add the bank in there to see if they can help compensate the adult for losses or so on. So again, from a very practical point of view, it isn't just call the police, whatever. Sometimes it's speaking directly to the financial institutions. Again, you have to have some kind of credible evidence, not your suspicion about, they're driving the person's car. But if speaking to the financial institutions might get you some relief or some delay in loss or something of that nature. But as Amy said, there really is no other legal mechanism other than what's in the Powers of Attorney Act to request that accounting.
Perfect. Thank you both for that. Okay, another question here. We have 3 more, so I'm going to buzz through them quickly so we can hopefully stay on time a little bit. Some banks will accept a copy of an EP of an enduring power of attorney. Other banks want the original, and we cannot locate it. Some banks will reject enduring powers of attorneys if they don't agree on the format. Another bank will accept the same one. So this results in a situation where the family has to pursue trusteeship, even though there is a document in place that is accepted by Government of Alberta Programs and Services, the federal government, but not the donor's bank. This is extremely stressful, the attorney and everyone else involved. I don't see a question here. I'm guessing it more or less has to do with, we can't give advice on that, but if there's any way, Amy or Lincoln, that you'd like to respond to that.
I think what I will say is I completely understand the concern that has been raised here, because I have I'm aware of situations like what's been described here. And I think some of the difficulty is that different financial institutions, a lot of the major banks have their own estate departments that handle these things. And there can be a variance between the financial institutions in terms of what they will accept versus what another bank might. I think sometimes the difficulty comes in perhaps when you're dealing with someone at the bank who is actually not accessing the legal department who deals with these things, and they are applying their own understanding of the law and what is required. And so all you can really do, I think, is push back as much as possible in those situations, and perhaps try to escalate through the proper channels, perhaps through the manager, and then the suggestion that it be reviewed by the bank's legal department, which can sometimes resolve some of these issues.
Perfect. Okay. Another question. Can you state that you want your agent or attorney to get paid for their services in time? Which one of you? Amy?
I can field that one. So yes, and actually it's important if you do want your agent especially, but both, if you want them to receive compensation, that should be put in the document. The Personal Directives Act actually says that an agent isn't entitled to compensation unless it's specifically stated in the personal directive. So very important to have that language in the personal directive if you want that person to be compensated. And you might also want to consider saying whether you want them to be compensated for out-of-pocket expenses they incur as a result of carrying out their duties. With the power of attorney, there isn't the same language in the Powers of Attorney Act that I'm aware, and there's some argument that there can be sort of what we call a common law entitlement to compensation for an attorney because they're like what we would call a trustee. However, best to put that in the enduring power of attorney so that it's clear that you want that person to be compensated if that's your wish.
Perfect. Okay, next question. I completed an enduring power of attorney at Primary Care Network. Would this be valid with respect to the concerns raised? And I think that was following on the question of the validity or templates. I think that followed from there. Lincoln.
Because it's a power of attorney question, if you'd like me to answer that one, Lincoln, I'm happy to. Without seeing the power of attorney, I can't comment on whether or not it would be valid. But if it was a form that was provided by the Primary Care Network, I would hope that it would cover what's required. So if it's provided by an agency like that or an entity like that, I would hope you can trust that it covers what's needed, but I can't comment specifically on that form because I haven't reviewed it in terms of whether it would meet the requirements of a valid power of attorney.
Perfect. Thanks, Amy. And final question, as a service provider, I struggle with speaking with the bank. So I think this references your comment earlier, Lincoln, but also balancing the needs of protecting the client from fraud. Any thoughts? Did you want to follow up on that, Lincoln?
Other than certainly the public trustee's office, as even the government trustee for a number of people, we've had our own challenges with the banks, and some of the financial institutions are better to work with and some are less better to work with, less easy to work with. Often we have said to people, particularly we have trustees who have a lot of difficulty when they're getting, or in this case might be an attorney who's just been appointed trying to get everything underway. One, that is a situation where, having a lawyer involved, maybe sending some letters that say, this is the legislation, just pointing out if you've been named as an attorney under a valid enduring power of attorney, how you have these authorities and so on. That can be of assistance. But we've said to some individuals, you might just, because as an attorney you have that authority, you might just want to think about switching financial institutions, because in the end they have their own giant rule book, and often they feel their giant rule book takes precedent over what our statutes say, and it's really difficult to get them to change their mind. It's often easier for you to go to a more agreeable financial institution who can do the same thing for you, but with less stress.
Perfect. Thank you, Lincoln. Okay, well, we've addressed all of the questions. I see we're slightly 5 minutes over. So I'm going to wrap it up there this morning. We've had lots of great discussion. I want to thank Lincoln and Amy again for participating this morning, sharing all of your knowledge with us. Truly appreciate it. I hope everyone got as much out of the session as I did as well. So thank you again. So a couple things. One, join us in 2 weeks for our final webinar on the Adult Guardianship and Trusteeship Act. Like I said, Lincoln and Amy will be back for that one. And as well, when you leave the presentation this morning, you'll be prompted to complete our evaluation survey there as well. So if you haven't already done it, please take just 30 seconds to do that. It's just a couple of multiple choice questions, and we really appreciate your feedback. And other than that, I'm going to wrap it up there this morning. So thanks everyone, and have a great rest of your Wednesday.